Breaking news: Uphold justice, equity, fair play in Nnamdi Kanu's trial on terrorism charges. Igbos in diaspora, tells the judge. The Igbos in diaspora have again canvassed for justice, equity, and fair play in the trial of terrorism offences brought against the leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, by the federal government. The group specifically pleaded with the trial judge, Justice Binta Onyako of the Federal High Court in Abuja, not to tilt in favor of the federal government in the trial, but to uphold fairness and the sanctity of judiciary in resolving the matter. In the letter signed by Dr. Sylvester Onya and Gotino Biago, Avid President and Secretary respectively, they begged the judge to consider the admonitions of the Supreme Court that the bail earlier granted him ought not to have been revoked. Justice Nyako had earlier refused the oral application for bail argued by Kanu's lead counsel, Aloy Ejiamako, and directed that the request be made in writing on the ground that the Federal High Court is a court of record. But the group said that the request should have been granted in view of the deteriorating health condition of the IPOB leader. The same prisoner of conscience was unjustly arrested, and even after fleeing his home due to government invasion, he continues to face unjust imprisonment. His parents were also subjected to physical, emotional, and mental torture, leading to their death. Injustice to Kanu is injustice everywhere. A court of appeal in Abuja had last year discharged Kanu from terrorism charges against him by the federal government and ordered his immediate unconditional release. Meanwhile, Justice Nyako will on May 20 rule on the request for restoration of Kanu's revoked bail and the removal from the custody of the Department of State Services to house arrest or prison custody. The court fixed the date after taking arguments from Kanu's legal team, led by Aloy Ejiamako, and that of the federal government, represented by Adeboyega Awomolo-San. He told the court that he would have been killed if he had not escaped the way he did, and accused the federal government of misleading the court to get the bail revoked in his absence. He also asked the court to set aside the arrest warrant issued against him by the court while he was out of the country. In a separate motion, also argued by his legal team, Kanu requested for his removal from the custody of the DSS to a house arrest, or in the alternative, to remand him in prison. However, the federal legal team, led by Adeboyega Awomolo-San, opposed granting of all the requests made by Kanu. The senior lawyer said in criminal matters, no defendant has the right to dictate to the court how his prosecution would be conducted. The senior lawyer argued that the first request for bail by Kanu is a gross abuse of court process, having been rejected earlier by the same court, adding that the only option open to the defendant is to go to the Court of Appeal to challenge the rejection, since the High Court cannot overrule itself. On the request for removal from DSS custody, Awomolo said that the only safe and secured environment for Kanu remains the DSS custody in the interest of the safety of his life. He urged the court to dismiss the allegation of hindered access to lawyers by Kanu, adding that in his application and the supporting affidavit, Kanu did not name any DSS operative hindering lawyers from accessing him or eavesdropping during conversation with lawyers. And this is the news for today. Don't forget to like this video, comment under this video, and subscribe to this channel to get more news like this.